Welcome back to The Explainer, guys. Today, we are diving into a brand new, highly instructive Supreme Court decision from April 2025, Hisanza versus Bright Maritime Corporation. If you're a law student, a practicing lawyer, or gearing up for the bar exams, you're going to want to stick around for this one. It is a fascinating look at seafarer disability claims and the incredibly strict application of the 120/240-day rule. As you'll see, a single word on a medical certificate literally shifted the entire outcome of this case. To keep our analysis super clear today, we're sticking to the classic IREC method. We'll hit the facts of the case, look at the lower court rulings, define the main legal issue, break down the Supreme Court's decision, analyze the core legal ratio, and finally wrap up with the key takeaways for your bar prep.
All right, part one, the facts of the case, a seafarer's injury at sea. So meet Aden de Guzman Hisanza. He's an able-bodied seaman, meaning his job involved some seriously heavy physical labor. On May 24, 2017, he felt this severe, debilitating back pain while working and had to be medically repatriated to the Philippines 5 days later, on May 29. Now, pay close attention to the timeline here. December 5th rolls around, which marks exactly the 190th day since he got back. Remember, the law gives employers an initial 120 days to treat and assess an injured seafarer, which can be extended up to 240 days. So at day 190, we are sitting right inside that extended window. On that 190th day, the company's clinic issues an assessment. They give Hisanza a grade 11 disability rating for slight rigidity in his trunk. The company basically says, all right, this is our final word, and they completely cut off his medical treatments. Well, Hisanza's obviously still in serious pain, right? So he goes to his own orthopedic specialist, Dr. Gerdus, who finds something totally different, a grade 3 disability, declaring him completely unfit to ever go back to sea. So we've got a classic standoff here, the personal doctor's grade 3 permanent total disability versus the company clinic's grade 11 partial disability.
Moving on to part two, the lower court rulings, or how the third doctor rule got misapplied.
Hisanza files a complaint, but man, the procedural history here is a tough pill to swallow for a seafarer advocate. Step 1. The labor arbiter at the regional arbitration branch sides with the company, awarding just the grade 11 benefits. Step 2. The NLRC flat out denies his appeal. And Step 3. The Court of Appeals dismisses his petition entirely. All 3 lower tribunals hit Hisanza hard on one specific technicality. He didn't initiate a referral to a third, mutually agreed upon doctor. You guys know the standard rule. If there's a conflict and you don't get that tie-breaking third doctor, the company's doctor's assessment automatically wins out.
Which brings us to part 3, the main legal issue, the absolute crux of the case. Hisanza didn't give up. He elevated this all the way to the Supreme Court, arguing that the lower courts missed a massive foundational step. And the entire case, literally the whole shebang, hinges on this one critical question. Was the company physician's December 5th assessment actually final, conclusive, and definitive? Think about it. If it was final, Hisanza loses for skipping that third doctor rule. But if it wasn't, the entire legal landscape completely shifts. Let's look at part 4, the Supreme Court decision, a total reversal of fortune. The Supreme Court actually granted Hisanza's petition and completely reversed the Court of Appeals. They awarded him a whopping $60,000. That is the absolute maximum compensation for permanent and total disability under the POEA-SEC. And they even threw in his sickness allowance and attorney's fees too. So how did we get here? Part 5, the core legal ratio, examining the assessment. Why exactly did the Supreme Court overturn 3 layers of lower court rulings? Well, they looked straight at the documentary evidence. That December 5th assessment from the company doctor, it literally had the heading 10th Progress Report. The court pointed out that since it was issued on the 190th day, calling it a progress report inherently means, well, there's still progress being made. The process is ongoing, especially since they still had 50 days left on the clock in that extended 240-day treatment window. Let's actually zoom in on the exact words the attending physician used in that report. Under the plans section, the doctor wrote, "Physical therapy is continued." And then, this is the kicker, they wrote, "An interim disability grade of 11 is given." The Supreme Court pounced on this. They highlighted that the word interim, combined with the instruction for continued therapy, completely destroys any claim that this was a final assessment. I mean, the company basically admitted, through its own doctor's pen, that Hisanza still needed rehabilitation. And this brings us to the strict legal definition established by jurisprudence. Under the POEA-SEC, a final medical assessment has to be exactly that, definitive. It must clearly state whether the seafarer is fit to work, or it must give the exact disability rating without requiring any further condition, treatment, or action whatsoever. It absolutely cannot be incomplete, doubtful, tentative, or provisional. So by cutting off Hisanza's treatment prematurely based on what was just an interim progress report, the company totally breached its obligations. Finally, let's wrap it up with Part 6. Key takeaways for bar takers, the labor law doctrines you need to know. Okay, grab your highlighters because here are the 3 ironclad rules you need to memorize from this digest. First up, interim assessments do not stop the 240-day clock. An employer cannot just wave a progress report around to justify cutting off medical treatment early. Second, and this is a heavy hitter, failure to issue a valid final assessment within that 120 or 240-day period leads to ipso jure, or by operation of law, permanent total disability. Because Bright Maritime failed to give a definitive assessment before time ran out, Hisanza was automatically deemed permanently disabled, period. And third, the mandatory third doctor referral rule, it's completely moot if there isn't a valid final assessment from the company doctor to begin with. You simply can't be penalized for failing to dispute an assessment that, legally speaking, doesn't even exist yet. It's honestly a fascinating look at how strict procedural timelines serve as the ultimate equalizer in labor law. If you found this case digest helpful for your bar prep or practice, please make sure to like, comment, and subscribe to PHCodal for more high-yield legal explainers. But before we go, I'll leave you with this provocative thought to debate down in the comments. Do these rigid 120 and 240-day timelines ultimately protect the deep pockets of the maritime companies, or do they actually serve as the strongest shield for the injured seafarer? Let me know what you think. Keep learning, stay focused, and I'll catch you in the next explainer.